Another dirty trick to get you to default when you're sued for debt.
Another dirty trick by the debt collectors to get you to default when you're sued for debt. Hi, this is Ken Joubert at YourLegalLegUp.com. If you're being sued on a debt and the petition, that's the part that says what the debt collectors want and why they think they should get it. If that includes language that this is a communication from a debt collector, or this is an attempt to collect a debt, or especially if it includes a supposed right to seek verification of the debt, I believe you should consider bringing the counterclaim under the Fair Debt Collection Practices Act.
I've mentioned the way debt collectors will include fake affidavits sometimes to get you to think that they have more information than they do, so you'll give up. Including this warning is another similar trick. What's so wrong about including the statement? The debt collectors may argue that they just do it to make sure that they aren't violating the FDCPA's rule requiring that their communications include that warning. Or as a helpful reminder, sort of as a public service, they would have you believe. Don't buy it. The law is clear that a petition is not an initial communication and does not require the warning. And as a public service, don't make me laugh. The debt collection industry is notorious for being willing to take the last scrap off your table, if they could sell it. So what's really going on? Why do they really include the warning? It is intended to trick people into the wrong belief that if they dispute the debt and seek verification using a letter or a phone call, they don't have to answer the petition. They're trying to get you not to answer the petition. And if you don't answer the petition, you will default and lose your case. That's what they really want. There's a widespread understanding by consumers that they sometimes have a right to request verification, or sometimes it's called validation. The FDCPA provides that right at 15 U.S.C. 1692 G.A. that within 5 days of the initial communication by a debt collector, the collector must inform the consumer of his or her right to dispute the debt and to require verification. And if the consumer does dispute the debt and does request verification, the debt collector must not take any further action to collect on the debt until verifying. That's close to the part of the law that requires them to tell you that this is an attempt to collect a debt, and any information that you provide will be used for that purpose. And the warnings are normally put very close to each other on debt collection letters, too. People have these two rights linked in their minds, as they are in the law. But you almost certainly do not have the right to seek verification when the suit is filed. The law is not quite totally clear on the question, but almost. The FDCPA specifically states that the petition is not an initial communication and does not trigger the obligation to give the warning. Also, the Federal Trade Commission, in its official commentary and opinions, states that debt collectors can continue to pursue legal action without verifying a debt, even if verification is requested after the suit is filed. And in every case of which I'm aware, any defendant who has attempted to seek verification instead of answering the petition has suffered a default. If you don't answer the petition, you lose the case. And that all makes sense from a legal point of view. If the FDCPA does require the warning and notice in some places, its failure to require the warning in other places should mean that there is no right to require verification when that notice is not required. At this point, that's obvious to lawyers. But obvious to lawyers and obvious to consumers are, in reality and in the eyes of the law, two different things, and the debt collectors know that for sure. Consumers see the warning that this is a debt collection effort and believe that there's a right to verify connected to it, as it was connected in every other communication from the debt collector. Why else would the warning be given? They are being deliberately led astray. Why do I say it's a deliberate attempt to mislead the consumer into seeking verification rather than answering the petition? Isn't that cynical on my part? Well, consider a few things. First, debt collectors start most lawsuits without the evidence they need to win. They don't even know if they can get it. And they don't need the evidence because most people default on these cases. My estimate is that between 85 and 95% of the cases default. That makes the petition by far the most important document the debt collectors will ever file in the case. Would they leave that to chance? Doesn't it make sense for them to do everything possible to keep the rate of default sky high? Second, remember that the debt collectors file hundreds of thousands of these cases per year, and all this by a relatively few lawyers. So actions which only fool a small percentage of people will have a very big effect overall. A lot of people have told me that they did get fooled into seeking verification rather than answering the petition, and that's why I'm doing this video. The debt lawyers all belong to associations and networks that share information among themselves. Do you think that the debt collectors don't know exactly how many people are being fooled by their pleadings? This is $1 trillion industry we're talking about here. With the petition being so crucial, and with so much information on hand, what do you think the chance is that something like this would be just a mistake? I don't think there's much chance of that at all. They know that people are defaulting. That's why they're doing it. Including the warning makes more people default. But even if you don't agree with me, and you're not sure that it's intentional, that isn't what the FDCPA requires for an action to be illegal. In fact, intention doesn't matter at all. The action is unfair if it can cause an unsophisticated consumer to misunderstand his or her rights and act to their harm. There is no justification for including the warning, and it does lure a substantial number of people to believe that they don't need to file an answer to the petition. Those are the facts. It is, in my opinion, a violation of the FDCPA to include that warning, which causes so many people to do something which hurts themselves. If your petition included the warning and you defaulted, I believe you could plead misconduct, the FDCPA violation, on the part of the debt collector as part of your motion to vacate the default. If your petition included the warning and you have answered, you might consider amending to add a counterclaim under the FDCPA. Doing so not only gives you the advantages of a counterclaim, but also opens up whole new areas for conducting discovery. Go to my website at the site that you can see on the page for my article on this topic. It gives more information on the right to verify and why I think debt collectors are breaking the law by including the bogus notice on the petition. It also discusses some of the discovery questions opened up by having this counterclaim and why those questions may give you power over the debt collector. I should tell you that I haven't yet seen a case where someone made this counterclaim. I'm telling you that I think including the notice violates the law. That's the way I see it. But you can't take this as legal advice.
Please look for my special announcement coming soon about some exciting new options and materials that I'm rolling out. There's going to be a lot of valuable material for anybody being harassed and sued by debt collectors, so hope to see you there.
Protect what's yours and don't let the debt collectors rip you off. My site and materials can help. Go to yourlegallegup.com. Get my litigation manual and forums, or get the videos and defend yourself. You'll be glad that you did. You may not consider this video or anything I say in this or any video as legal advice. I cannot give you legal advice, but as a former lawyer, I do know the legal process and debt law very well. So use what I say as a source of information and apply your own judgment to your case. To get more help on fighting debt collectors and their lawsuits, go to yourlegallegup.com. Get my litigation manual and forums. If you appreciate this video, please take a second and like it, subscribe, and friend me, as these things will help others find my videos and begin to learn more about the debt litigation process. Defend yourself from the debt collectors.